approximately 3:55 hours, officers were dispatched to Marathon, located at the specific location known as 4600 South Cedar Street in Lansing for a stabbing. Dispatch advised the caller stated he was stabbed by a male at 645 West Jolly, apartment 2 in Lansing. He was sitting on the ground next to a white SUV and the officer observed a laceration on the victim's left shoulder blade. He was transported to Sparrow, and the victim advised that he went over to a female's house later, identified as Nicole Villarreal, to pay her $50 for sex. He explained that after he gave her the money, she refused to have sex with him and started yelling for help. And then he proceeded to get stabbed in the back by a black male, later identified as defendant Rodney Porter. Victim had a laceration from the top of his left shoulder all the way down to the bottom of his left shoulder, and a mark on his left cheek that appeared to be a bruise. His injuries were not life-threatening. That's all we need.
The people are satisfied, Your Honor.
Satisfied, Your Honor.
Thank you. Thank you, counsel. You provided prosecution. I'm returning the police report. And counsel will stipulate that this was not done in self-defense or defense of another.
Yes, Your Honor.
We have the people.
People are satisfied.
This is docket 25495 FH, People of the State of Michigan versus Rodney Porter. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Jacob Perron on behalf of Rodney Porter, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand down. Sir, I have your address on Long Boulevard. Is that still current?
No, it's not there.
What address do I have on this? Do I have your current address on the advice of rights form?
1109, yes.
Okay.
No, it's not.
And are you a U.S. citizen?
Yes.
Were you on probation, parole, or bond conditions when the event you're pleading to occurred?
No,
Your Honor, before we sign that, can we approach? Be very brief.
Sir, have you taken any medication, used any marijuana, alcohol, over the counter medication yesterday or today? Are you supposed to be on medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no.
Have you had enough time to speak with your attorney?
Yes, Your Honor. The plea agreement is to an added count 2 of assault and battery. It's a 93-day misdemeanor. Public accessible plea and conviction. Count 1 will be dismissed, as well as the habitual offender 4 status. And I apologize, I'm realizing that's not on the plea sheet.
All right, I'm gonna add that to, I'm gonna grab the original.
I apologize, Your Honor.
You all can amend your own, I'm gonna amend mine.
I will do.
On page 2, item 3, I'm going where it says no upfront jail. I'm going to put, or no, I guess it's not there. So you're the.
It would be in 2A
Yeah, the
already.
2A, right. Under where it says 1, I'm going to add dismiss habitual 4. Now that's full, fair, accurate, and complete.
And there would also be a agreement to no upfront jail at the time of sentencing, Your Honor.
Thank you. Full, fair, accurate, and complete.
It is, Your Honor.
Sir, full, fair, accurate, and complete.
Yes.
All right. Counsel, you waiving reading in its entirety the habitual 4th offense notice as well as count 1.
Yes, Your Honor.
As to count 2.
Yes, Your Honor. People of the state of Michigan versus Rodney Porter, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney before this court, the prosecuting attorney for this county appears before this court and informs the court that on the date and at the location described below, the defendant in count 2, assault and battery, did make an assault or assault and battery upon a person, Daniel Lang, contrary to statute. This is a misdemeanor that's punished by up to 93 days and or $500. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes,
So you understand assault and battery is a 93-day misdemeanor, and you would be responsible to pay for any restitution, if any. Is there restitution?
There is restitution, Your Honor. I believe we have to have a restitution hearing unless they will stipulate to the restitution.
We'll address that between now and then.
And the victim is on board with this plea?
I have consulted with the victim, Your Honor.
All right, so you understand, sir? Yes?
yes, I do.
Okay. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did you understand what you read?
yes, I understand.
And I understand this is going to be a no contest plea based on civil liability?
Correct, Your Honor.
You agree with that,
Yes,
sir?
that's
All
right.
right, you understand that civil liability enters as a guilty plea for how it responds in the system,
Right.
although it's a no contest
I
plea for
understand.
civil liability. All
I
right,
understand.
very good. And sir, as to count 2 assault and battery, how do you plead?
Guilty.
No contest.
No contest, we're striking what you said, yes. And so based on civil liability, how do you plead?
No contest.
You understand that you are also giving up your automatic right of appeal if you choose to appeal, you first have to ask permission of the Court of Appeals to appeal.
Yes, I
You're
do.
giving up the presumption of innocence, the ability to hold the people to their burden of beyond a reasonable doubt, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, etc.
Yes, I do.
And sir, you pled of your own free will,
Yes,
and you did that after you consulted with your attorney,
yes, ma'am.
and you were satisfied with the representation of your attorney?
Yes,
Has
I do.
anyone, other than the plea agreement, has anyone told you what I will do at sentencing?
No,
Is the victim here, are we going into immediate sentencing?
The victim is not here, Your Honor. We will need some time for sentencing.
Okay, and so you understand that between now and sentencing, if you violate the law or bond conditions, then I don't have to honor the no upfront jail. However, if I don't honor it and everything's gone well, then I would allow you to withdraw the plea in this manner, we again go to the pretrial stage.
yes, I do.
Has anyone told you what I will do at sentencing?
No,
Because I don't know, I will make up my mind after I'm apprised of the facts. Right now, I don't know anything about your case, I'll learn a little bit, but at sentencing, I'll be fully informed, okay?
Satisfied, Your Honor.
Will you stipulate that it's
Oh.
not done in self-defense?
Yes,
or
he will
defense?
stipulate.
Thank you. And are counsel going to promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does court comply with the court rule?
You have, Your Honor.
It has, Your Honor.
I find defendant's plea has been of no contest based on civil liability to be appropriate in this matter. I also find that the no contest plea was freely, voluntarily, knowingly, and understandingly made without under influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter, count 1 and habitual 4 are dismissed in their entirety along with any outstanding warrants, if any related to this file. Do we have a sentencing date? We're not gonna get a PSIR, so we just
Understood,
need
Your Honor.
the victim to have enough notice.
Yes, and I believe that 2 weeks should be sufficient.
I don't have
Well, it's either
it 2 weeks out, but as soon as I have his June late.
Well, how about like next,
We could potentially do next Thursday, Your Honor. I would have no issue with next Thursday. I've been in contact with the victim, so I should be able to
Or
get notification to him by then.
potentially May first in the afternoon, because I know we have adult sentencings in the morning on May first.
oh, that's the morning?
Yeah, Friday morning on May first, we have adult sentencings.
Well, no, we're not talking about Friday, we're talking about, Thursday.
I don't know what it is, Thursday.
Thursday, the 23rd.
Oh, that's a week.
All right, let's do the 23rd at 1 o'clock. Does that work?
Yes.
Sir, you can be back here Thursday, April 23rd at 1.
yeah, it's my birthday, yeah.
Well, mine's the 25th, so happy birthday to both of us. How's that?
I can be it.
All right, then you can go out and have some cake. All right, bond conditions are continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
It started with a 3055 a.m. call to a Marathon gas station, a stab wound running from the top of a man's left shoulder all the way down his back, and a story that, once you hear it, makes you wonder exactly who the law was written to protect. The victim, according to the police report read aloud in open court, had gone to a woman's residence and paid her $50 for sex. When she refused and called for help, he found himself in a confrontation with Rodney Porter, who was at that address, and he was stabbed. His injuries were serious but not life-threatening. Rodney Porter walked into that courtroom the morning of a scheduled jury trial and entered a no-contest plea to a single count of assault and battery, a 93-day misdemeanor. The original charge was dismissed. The habitual fourth offender notice, which alone carried the potential for a dramatically enhanced sentence, was also dismissed. No jail was agreed upon. The judge made clear she almost never allows last-minute pleas the day before trial. She said it plainly. Porter got lucky. The victim was consulted and signed off. The legal system, for all its formality, ultimately reached a result that both sides agreed to, and the judge accepted it, after carefully and thoroughly making sure the record was clean. What makes this case stick is not just the bizarre fact pattern. It is the reminder that courtroom outcomes are rarely as simple as the headlines suggest. Charges get dismissed. Deals get made. Habitual records disappear into plea agreements. And sometimes, at the end of all of it, a defendant and a judge discover they share adjacent birthdays and agree that everyone deserves a piece of cake. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.